Today we talk how you get from an idea to a patent in a step-by-step approach. So for most inventors, typically what you want to do is when you come up with an idea, you need to capture and clarify the invention. That means you document everything, you write down what the invention is, what the problem it solves, and how it works, step by step with variations and alternatives. You need to also think of support materials, sketch diagrams, flowcharts, block diagrams, or prototypes. Focus on the structure, the components, and the method steps, not just the abstract idea. Then you should also think in claim-like terms. And what do we mean by that? The claim addresses the essence of the invention. You need to think about what are the essential elements. Think of it like a minimum viable product, except that this is for a claim. So what are the minimum requirements of the invention? So for example, in a car, you could think of it as a frame with 3 or more wheels and an engine. That would differentiate it from the prior art of a bicycle. So that is the minimum viable product for a car, right? So you need to think about what are the essential elements, what can be swapped out, and this will help you define your claim scope. Second step is to protect your confidentiality early on. You need to avoid public disclosures. In most countries, when you have a public disclosure, that kills your patent application. In the US, we fortunately have a 1-year grace period from the initial disclosure to the patent filing. Don't rely on that. What you should do is document your idea, file a patent application early, and then you can go and talk to your consultants or make an investor pitch deck, for example. And you need to use NDAs whenever possible. So confidentiality agreements or non-disclosure agreement, they're the same thing. If you must talk to your vendors, your investors, your potential employees, use a non-disclosure agreement to reduce the risk of accidental disclosure. And you need to control written disclosure. For example, the pitch deck, the websites, the white paper should be reviewed with patent strategy in mind before you make it publicly available. The next step is to conduct a prior art and patentability search. Traditionally, this is viewed as very important, but one way where you can avoid the need to go and search, let's say in Japan or in China, doing a global search is you can do a sanity search at, let's say, the US Patent Office or the EPO. Those are safe places to do search. And also look up the internet to see if there's any similar concepts floating out there. You don't need to be perfect because often there might be prior art that's unpublished. For example, people who file application within the 18-month window from your current date, those applications are secret, so you'll never be able to unearth that. So I think you do a reasonable sanity check on the novelty of your idea, but then you supplement that with a detailed description. And so what do I mean by that? When you have a 1-page description of your idea, most likely other people who are thinking about the same idea, they'll come close to that 1 page. But when you start thinking about 30 or 40-page fully fleshed out idea of how the thing works, the odds are very low that somebody else across the world would think of exactly the same implementation level detail. I think between doing a sanity prior art search and also focusing time on the depth of your disclosure, there you minimize the risk that somebody else is doing exactly what you're doing and it's going to knock you out from a patentability perspective. In the case that you run into something that's close, what you do is focus on how you differentiate and embellish on the differences, and that's how you space away from a piece of prior art that might be an obstacle to patentability. In step number 4, you need to choose your filing strategy. So there are 3 types of patents. Utility application that covers functions and machine systems, apparatus, software. Design patent application that covers the aesthetic or the appearance of an article that you're going to patent. And then you have plant patents. Most frequently, unless you're in the cannabis space or in agricultural technology, you're likely to be dealing with utility or design. And within utility, you have 2 types, provisional application and non-provisional. A provisional is designed to be a low-cost vehicle to get you patent pending. It is not examined and it expires within 1 year, and you need to convert the non-provisional into a provisional within that 1-year duration. So from a total cost perspective, going through a provisional and then converting it to a non-provisional actually costs you more in terms of money, and also it delays you from being examined. So Typically, once you file a non-provisional, it takes about 18 months before you get examined, 18 months to 2 years, something like that. Now, if you do a provisional first, you are tackling 1 year ahead of that. For most software technology where things are moving rapidly, most people just go straight into a non-provisional so that you can get examination early, and then you can tell your investor the patentability determination at the patent office. So those are the different approaches that you can do. You can also need to think about territorial, i.e., do you want just US or do you want international? And if so, which country? There's also another vehicle that is in between. That means you can file what is called a PCT that delays that decision out 30 months from the first priority. You can file a non-provisional or provisional on, let's say, January 1st. And then within a year, you convert that into a PCT, or you file a PCT patent application. Then the PCT would then push the date that you need to select other countries besides the US, pushes that out by an additional 18 months. So a total of roughly 30, and in some countries, 31 months from the earliest priority date. If that doesn't make any sense to you, just call us at patentpc.com. Step number 5 is to file a patent application. And so this is where the quality makes or break the patent. As we discussed earlier, the claim basically sketches out what is the essence of the invention in a way that is novel over the known prior art. And so the claims tells you what you need to describe in the patent application. So what are the parts, the components of the application? You have the background of the invention, and the background lays out essentially the need for the invention so that a reader can get oriented interpreting what you're going to be talking about next. Then you have a summary of the invention, and sometimes the summary and the abstract can be very similar, right? In a summary of the invention, you discuss a high-level overview of your solution. Often people take a stylized version of the claims and use that as the summary of the invention. And then the same high-level summary of the overview of the solution can then also be used as the abstract. So often the abstract can track the first paragraph of the summary. Then you have what is called a detailed description. So the claims are supported by the detailed description. And so what you need to do is to describe how your invention can be used by somebody skilled in the art so that they can, let's say, build it or make the invention, right? And so the patent office has a requirement that your specification must be enabling so that somebody skilled reading it would know how to implement the invention. And that is a quid pro quo for getting your exclusivity through the grant of a patent. Last but not least, you need the claim, and we've discussed this a lot. The claim is like a legal fence around which you want to block people from being able to enter. So for example, if you're the first person who invented the car, your claim might be a vehicle with a frame with 3 or more wheels and an engine. That differentiates that from the prior art of a bicycle. And so you can see how that claim is very high level, and then it can cover quite a number of implementations that are flushed out on the car technology. So for anything commercially important, you may want to use a professional to review your work, if not to draft it for you. And that tends to provide you with a high return on investment because the claim strategy and the wording can be critical components of the patent application. And then step number 6 is to file the application. You have various formal documents such as the application data sheet, short for an oath or a declaration of the inventor. And if you have any known prior art, you need to submit that in an information disclosure statement or an IDS. You also need to pay the fees to the patent office, and once you submit all that, you get a filing date, and then it is patent pending. And then once you file it, assuming you're filing a non-provisional, you would enter a queue for examination, and that queue can be 18 to 24 months on average. And then you get an examination, and more than likely you're going to get some sort of a pushback from the patent office on, let's say, prior art or perhaps informalities, maybe in the drawings or in the description. So you'll have to address those before it is issued as a patent. But those are the rough steps in getting from an idea to an issue patent. If you have any questions, please visit patentpc.com. We look forward to working with you.